Welcome to this week's edition of Freedom and Prosperity Radio, the weekly radio news magazine that we put together here at the Virginia Institute for Public Policy. And we network lots of folks, and one of our favorite groups is the Pacific Legal Foundation. I'm sure if you go to our YouTube channel, you'll find plenty of archived visits. And one of the subject matters that we find most frequently discussed at tertiumquids.org and our Tuesday morning group coalition meetings is property rights. Property rights are, simply put, the beginning of it all. If you cannot be sovereign in your property, you can't be anything, really, quite honestly. And that's why we begin this week with the case of Knick versus Township of Scott in Pennsylvania. And our first guest to help us get into the story a little bit, give us some background on where we stand in it, is one of the attorneys that work with the Pacific Legal Foundation, Christina Martin. Christina, thank you for taking some time out with us this week on Freedom and Prosperity Radio. Am I overstating the importance of private property ownership rights in our American construct?
No, property rights are extremely important to protecting your other rights, because if you don't have property rights, then how can you have ownership over even your own yard, your own money? How can you express your First Amendment right to speech if your money can be taken away, or your land can be taken away, your signs can be taken away without any means of protecting that right? So in many ways, and many people have called property the guardian of our other constitutional rights. And so, yeah, property rights are incredibly important.
So take us into the case of Knick versus Scott Township in Pennsylvania. I've faced property rights issues in Pennsylvania in years gone by. In Lancaster, the Saha case, I was center square of that, where the towns just want to take and do as if they are the great arbiters of all things. So take us into this case and what was ruled, because good Supreme Court ruling on this, if I understand correctly.
Absolutely. So the Township of Scott in northeast Pennsylvania actually passed a very strange ordinance that gave local officials permission to go onto our client's property. Rose Knick has a farm, and local officials went on our land, found some loose, unmarked stones, and decided those stones were gravestones, and declared this part of her land a cemetery, and threatened Rose with fines if she didn't open up her private property to the public. Now, Rose does not believe there's a cemetery on her property, but the town wasn't concerned with what Rose thought. Instead, they just unilaterally decided it's a cemetery and threatened her with $600 per day fines if she didn't allow strangers onto her public 7 days a week, or onto her property, I mean, the public at large, not just supposed family members of whoever might be buried on this piece of land, but the public at large. And they said $600 per day fines if you don't do it, and also another $600 per day if you don't maintain the area as if it's really a cemetery.
Right.
And so Rose went to court, and she tried to enforce her property rights, and she tried first in state courts. And the state courts wanted her to wait until the government actually acted on those threats of fines. And so she went to federal court to enforce her Fifth Amendment right that says that when government takes your private property, it has to pay you for it. And here the government imposed a public access easement on her property, meaning that the government should have to pay for it. But she was actually thrown out of federal court because of a 34-year-old decision that closed federal courts to these constitutional claims that enforce property rights. And fortunately, just this last month, and at the end of June, the Supreme Court overturned that decision and ruled in favor of Rose Knick, opening up federal courts to property rights claims.
It is one of the scary things. It sounds so familiar to something that happened here in Virginia with Martha Bonetta and her Liberty Farm. But in that case, it was actually the previous owners of the farm trying to get it back by forcing her out of it and using the idea that somehow I don't know, Stonewall Jackson or George Washington or somebody, pitched a camp there, and they had records that they claimed said that her property was now this historical site and she was going to lose access to it. She'd still have to pay all the taxes on it, but she was going to lose the ability to farm on it for this, I'm sure, unless she, sold it back to the original owners. And that kind of thuggery, I like to call it skull thuggery, just based on, the turn of the phrase, but it really is sometimes what these government agencies are trying to do. It isn't even so much for their own engrossment. It's they're trying to help a friend either get some property to develop, or a farmer hasn't decided to help some. In the case of Dick Saha, they wanted to build a municipal golf course and they needed an acre or two of his land, which I actually had a municipal leader say, it's just an acre or two. What is he so upset about? And I was like, that's the arrogance of this. It's like, it's not yours.
That's exactly right. And the Constitution says very simply, if government wants to take your private property, it has to be for a public purpose and public use, and it has to pay you for it.
Mm-hmm.
And
exactly.
Here, the problem is the government doesn't want to pay Rose for her land. Instead, they want to just open it up to strangers. They are not worried about the risk to Rose of having strangers on her land and the liability of having strangers wander onto her property. It's a functioning farm, and there's farm equipment there. Rose is very worried about that, understandably so.
Mm-hmm.
And so, ultimately, local officials often ignore what the Constitution says, but the Supreme Court, fortunately, in overturning this 34-year-old decision that closed federal courthouse doors, clarified
mm-hmm.
that when government takes your property without first paying you for it, it violates the Constitution's demand. And so that means property owners can go straight to federal court.
So, it was a 5-4 decision, and we're going to see a lot of these. Was it the traditional 5 conservatives, 4 liberals, or was there an interesting mix? Did any of the supposed left-wing judges get the idea of Fifth Amendment protections and the importance of them, or was it straight quote-unquote?
It was 5-4, and the reason, there were a couple of reasons why the liberal justices dissented. They said one reason was they were concerned about overturning the court's precedent, and the other reason was they were worried about making local officials accidental lawbreakers, because sometimes local officials pass laws without realizing that their local regulation is going to take property without paying for it, and so they think that officials should have the opportunity to pay you once a court declares that its actions actually took private property in violation of the Fifth Amendment unless it's paid for. And so they don't want it to be called a violation. They want it to be called something else, give them a chance to remedy it. But fortunately, 5 justices understood that when government takes your private property without paying you for it, through a regulation, even if it's accidental, it's still a violation of your right. And officials have a duty to try to avoid taking your property. But on top of that, property owners already bear the extreme burden of having to go to court and prove this. Why should they lose out on the right to have their right vindicated? I mean, they're telling Rose that even if the government violated her rights through this, in effect, the way that the dissenters would have it is Rose lost her property rights, but she would have to go to court. And then if the government's law did, in fact, create new rights for the public on her land, then she'd be paid for it, but the government would never admit that it violated her right, and the court wouldn't say that it violated her right. So that's unfair, and I think just people understand that on a gut level. If the government took your property without first paying you for it, we should all be able to agree that that's a constitutional violation. It's not remedied just by money, but also by a recognition that the government did something wrong. And as Justice Roberts put it, he said a bank robber, Justice Roberts wrote the majority opinion, he said a bank robber may return the loot, but he still robbed the bank.
Yeah, Absolutely, with the intent of not returning it if not caught for it. And I'm just gobsmacked by the phrase accidental lawbreakers. Aren't most of these people, and believe me, I would love to have more and more elected officials that aren't longtime lawyers passing bars and everything else, but I think there's an awful lot of lawyers in there. But considering how many of these elected representatives are lawyers, and most municipalities have at least a couple on retainer, somebody should be able to say, hey, it's only a couple of sentences in the Fifth Amendment. You've got to stay true to that.
Well, they really should stay true to it, absolutely. But, the government accidentally violates the law all the time. We see this in, for example, search and seizure cases where a police officer accidentally goes too far. He doesn't have probable cause when he does a search. It happens all the time. And courts haven't decided to compromise our Fourth Amendment rights just because it might be an accident that the public official violated the law. He went too far. For the same reason, it's really important that courts protect our property rights, because you don't want to say, well, they don't. We shouldn't put this burden on government to, not violate the law. Well, the burden is not that big for government officials under the current state of things.
Well, as you said,
the burden for the individual property owner is extreme.
Yes, and as you said, if it was the other way around, the burden, I worry that there might be some subtext in the liberal judges' view of property rights in general, especially given the activities at the border and some of the hearings I've watched on Capitol Hill regarding reparations. I think that there is a movement to create this common sense, and I'm going to put it in air quotes because it's neither common nor sensible, but this idea that property is a fluid concept and that government really needs to rule as to whether you should have it or not, because there are people who don't have it, and you've heard all the progressive arguments, Christina. So is there a danger that if we're not strong on this, that we're creating that wonderful legal mischaracterization as precedent, and then the government can start deciding whether you have property rights or not just based on their whim?
Well, to an extent, and I don't want to overstate this, so don't hear what I'm saying. But to an extent, the government is already defining away property rights. So I think all of the justices would probably agree that if government takes away, and this is based on previous decisions that I'm drawing this conclusion, that if the government takes away title to your property, they seize it, they take it, and you haven't done anything wrong and they're taking it, they have to pay you for it. But what's happening today is that government regulates away the use of your property. They regulate away your rights to your property to the point where you have only a shadow of the rights that you once had to that property. And that's where it starts to get sticky. So, it starts to get complicated, and I think you start to see disagreements about the rights of the property owners. And right now, the Supreme Court precedent says that if the government regulates away all economic use of a parcel of land, then that is a taking in violation of the Constitution. But it starts to get difficult when there's still some use to it. So maybe you can build a shed on it. Maybe you can have a
kids
dog.
can play on it. What about things like the EPA's ruling that anything can be considered a navigable waterway? And we see this play out, in little, 3 months out of the year, there's a stream on somebody's property, and the EPA comes in there and says it's a protected wetland. Is this a ruling that we could use to kind of get back those property rights, do you think?
Well, sure, and we are actually fighting those, though, on the law itself, as opposed to having to argue that it's a taking without just compensation. We're actually fighting that determination because the Clean Water Act, it's only supposed to apply to navigable waterways. In other words, you should be able to put a boat in it and row around in it.
You'd think.
And instead they're applying it to all sorts of waterways that the Supreme Court, I think, has made clear in the past don't apply. And so we actually have a number of challenges, Pacific Legal Foundation does, to the rulemaking that would declare things like, a puddle on your land for a few weeks out of the year is a navigable waterway of the United States. that's subject to the Clean Water Act, and if you accidentally move dirt into it, you've now polluted it. I mean, that's just outrageous. You shouldn't have to go get a permit from the federal government,
But it happens.
Yeah.
And all too well. Please support what they do. Read about it. PacificLegal.org, and then you can follow the case, the Knick v. Township of Scott. But Christina, thank you so much for joining us this week on Freedom and Prosperity Radio. Christina Martin, one of the attorneys that helped do this at the Pacific Legal Foundation. Thank you so much for your time this week.
Thanks for having me.
More hot and the guy was just complaining about lawyers. I got another lawyer on the line, Chris Horner, author of Red Hot Lies, Power Grab, and what exactly is climate apartheid? Coming up next on Freedom and Prosperity Radio.